Hello and welcome. You're watching News9 Live. My name is Pankaj Mishra and with me is my colleague Brijesh Pandey, the political editor of News9. And also, the issue that we are discussing today is something that is making headlines every day. This is the fifth day of the same-sex marriage case in the Supreme Court. Now, the Apex Court's five-judge Constitution bench resumed its hearing today on day 5th on a batch of pleas seeking legal recognition of the same-sex marriages in India. The bench is led by Chief Justice of India, D.Y. Chandrachud, and also comprises Justice Sanjay Kishan Kaul, S. Ravindra Bhatt, Justice P.S. Narasimha, and Justice Hema Kohli. On day 4, the five-judge Constitution bench was prima facie unanimous that even if it decides to grant marriage rights to same-sex couples, it will refrain from determining consequential rights including adoption, succession and inheritance, as these are inseparably linked to religion-based personal laws. The centre has also filed an application asking the court to first decide on the maintainability of petitions. Well, this is something that has transpired so far. Yesterday also the court posed questions on the ramifications and its impact. Brijesh, well, in Indian context, the issues of succession, adoption and inheritance, this is something that since day one we have seen has been somehow a bone of contention or a debatable topic as far as this case goes.
Well, absolutely. And, yesterday also Chief Justice of India, Chandrachud, he went on to say that, we'll also have to see how far we can go without touching upon the personal laws. And he also wondered aloud that, how far the court can go, the Apex Court can go, because the couple of key issues are within the domain of the Parliament. See, interesting is that Karuna Nandi, who's arguing, and I think her argument is about to end soon before the Solicitor General Tushar Mehta starts the argument on the part of the government. They're saying that it should be allowed. There should be no problem at all. And when asked about the numbers, they're saying that a lot many people do not come out. And she gave example of Supreme Court itself that a lot many people do not come out because they're demonized by the society, and not everybody has a bandwidth to move ahead and announce himself as a gay or queer, or that someone who intends to go for the same-sex marriage. Right. So it'll be extremely interesting to see how the government goes about it, because the government has yesterday also told the Apex Court that that they would want a discussion on the maintainability of the pleas which has been filed before it. Interestingly, Bar Council of India and a couple of other lawyers body, they have written to the Supreme Court saying that this does not fall within the domain of the Apex Court, and let the Parliament adjudicate over it.
Right, obviously, Brijesh, and the way out, the purview of the religious law, all those things are coming under the UCC purview, whether it could help the same-sex couples or not, that we will be discussing. But before that, let's quickly dip into the Supreme Court live proceedings that we are bringing to you as the case proceeds in the Apex Court.
Religion. And what we must understand, my lord, is at this time, until the coming into force of the Hindu Marriage Act 1955, this would have been the law for any intercaste marriage. Therefore, my lords, it followed, and I'm cognizant of the time, therefore it followed that, as I've set out in the second table, certain restrictions on the application of personal law were imposed, and at this point in time, it was the most onerous. If my lords will see table B, where I have given the provisions of Act 30 of 1923. Firstly, my lord, in 22, as now, it affects severance from the joint family. Secondly, my lord, the Caste Disabilities Removal Act, my lord. Thirdly, my lord, there were provisions that a man could adopt another son, my lord, in section 26. And, my lords, under section 25, no person who adopted under this law would have the right of adoption. Who married under this law would have the right of adoption, and under section 24, the Indian Succession Act would apply. Next, my lord, came the Special Marriage Act 1954. And this statute, my lord, is also in 54. We are in the middle of the debates about the Hindu Code Bill. And 1955, the Hindu Marriage Act follows. So now, for the first time, there is a unified civil law for the Hindus. There is a unified civil law of marriage for the first time. And under that law, intercaste marriage and intergotra marriage is now permissible. And therefore, the restrictions which are adopted in the application of personal law are modified to those under 19, 20 and 21 which we have today. In 1976 comes the final Marriage Laws Amendment Act, which brings in the provision of Section 21A, which now exempts those Hindu couples who marry under the statute from the provisions of 19 and 21. What, my lord, does this history tell us? As far as the application of personal law, since it fell from my lords, as far as the application of personal law is concerned, to a couple who marry, who may be LGBTQ, but who marry within their faith, those statutes which are contemplated as applying under Section 21A will continue to apply. That is my submission. Now, what will be the extent of the application? How will those statutes be read? These will be questions, my lord. Courts may hold, my lord, that we are excluded altogether, that there is no provision for the application. But how will those questions arise? In what circumstances? To which persons? Those are, my lords, questions which, as my Lord Justice Bhatt perhaps indicated, will arise on a factual basis with the passage of time in different circumstances. But my submission, my lord, would be this, that per se, in my lord's reading of the Special Marriage Act, Section 21A must continue to apply to Hindu LGBTQ couples. There can be no per se exclusion of Hindu couples who choose to remain within their faith for the matter of who they choose to partner with. In 50 years, I would submit, my lords, this section has not created any major difficulty with respect to its interpretation to opposite sex couples. And my next submission is this: my lords should not presume and pre-anticipate a difficulty which would arise for LGBTQ couples. On the one hand, the union submits that it would play same-sex marriage or LGBTQ marriage would play havoc with personal law. On the other hand, we tell your lordships that we are part of our societies and our communities. Our parents also long for our marriages just as those parents of opposite sex couples. They long to see that day, your lordships. So let us not assume, yes, there are cases, my lords, where a family may oppose a marriage. Those cases exist for opposite sex couples also. And how have your lordships and the union responded? Your lordships have responded by saying from a series of cases in Lata Singh's onwards that the state is enjoined to protect such couples. And the union has also risen to the occasion. The police protect such couples as today they protect us when we approach the courts. And the state also responds by offering, for instance, under the Dr. Ambedkar scheme, under the Ministry of Social Justice and Empowerment, special schemes to promote intercaste marriage. So, my lord, it cannot be presumed, because today we are going through a process of social change, because today we are at the threshold. Neither this court nor I would humbly submit the state should presume that there is going to be a certain kind of outcome. They should see their people. It is not only a question of elites, my lord. We receive calls and we hear from young people across this country. From the inception of this case, my lord, I have received calls from people in Hisar, in Surat, in Chhattisgarh. When I asked, which district are you from? They said, which district? We are from Raipur, we are from Rajnandgaon, you name it. Let us not assume any more than we would assume at the outset of embracing any section of our society within the fold of law. Let us welcome them. Let the union welcome us and bless us as it would bless any other married couple, my lords. We seek those blessings. So, my lord, my last submission, therefore, is this, and now I promise I will wrap up, is that when it comes, therefore, after we marry, to the application of laws must be uniform for both same-sex and opposite-sex couples. On the one hand, my lord, there are general civil laws, for example, as fell from my lord the Chief Justice yesterday, of gratuity, pension, inheritance, succession, and so on. And my lords, those laws, the word spouse would be read in, the word husband or wife would be interpreted in a gender-neutral fashion, and my lords, where a person would otherwise nominate their spouse of the opposite gender, today we would be nominated as spouses of the same gender. The other question, my lord, is the question of having children. Now, it fell from my lords, and very rightly, my learned friend, Mr. Vishwanathan, also said that today, perhaps not all couples wish to procreate. Not all couples who marry shall have children, and nor is having children a condition of any law. But my lord, as a couple, as a married couple, having a child is part of the human experience. And it may be something that some also long for. Today, marriage is a gateway for couples to have children as per the legal framework. So under, my lord, the JJ Act, the adoption regulations require that a couple have been married for a certain number of years, that there be a stable marital relationship and so on. This is, my lord, for a couple to adopt. Now, my lord, similarly, under the Surrogacy Act, only married couples may opt for surrogacy with some provisions. And the child who is born of surrogacy is protected under Section 8 in the same way as a child who is born of, let us call it, natural methods or a natural born child. Similarly, my lord, the adoption statutes say that at the moment of adoption, an adopted child, there will be a severance with the biological family, and the adopted child will have all rights and obligations as a biological child does. Now, what is the import of what I'm saying, my lords? There are already couples in this country who have children, LGBTQ couples, and those couples are also before your lordship. In the absence of the recognition of marriage of their parents, what the law does is it renders, just as it renders one partner of the relationship a stranger to the other, it also renders a child a stranger to its parent-in-law. That child has no relationship in law with one of its mothers who may love her equally as a mother in an opposite sex couple, who may do everything from morning to night as a mother does in an opposite sex relationship. But that child, my lord, without the protection of law, without the protection of adoption law, or the provisions of Section 8 of the Surrogacy Act, or similar provisions of the Assisted Reproductive Technologies Act, is rendered a stranger to its parents. That, your lordships have held on numerous occasions, is constitutionally untenable. A child cannot suffer because of the parents belonging to a protected class under Article 15. This is the sum and substance of my submissions, my lord. I'm grateful for a very patient hearing to this side. I'm obliged.
Now, we now have four remaining counsel, Mr. Raghav Avasthi, Mr. Shivam.
Well, there we saw the live court proceedings from Supreme Court. Advocate Arundhati Karju making her submissions. And Brijesh, interesting facts there. And when we began this show, obviously there are so many facets to it. If we take a fine-tooth comb, then what Advocate Karju was mentioning here is quite worrisome, also needs a closer look as well about the difference between adoption and surrogacy, the way same-sex couples would adopt a child. In that scenario, would the rules applying for surrogacy be applicable on that particular child or not, or what solution does one have to look at it? All these complex issues, Brijesh, do you believe that the process that is being done is more than welcome? But are we ready for it?
See, we are, the question is, if the bottom line is that are we ready for it,
Right.
then, there comes a point when most of the social evils we got rid of, we were never ready for it at that point of time. The Sati abolition met with a lot of, against opposition, and, people fought against it and said that, no, what is happening is right, it is part of a religion, but it was done away with. Same was,
Right.
Underage marriage. And there are various social evils, once you take a decision against it, it generates a lot of controversy, it generates a lot of chatter on the ground. But then you have to take certain decisions to benefit society at large. See, right now, when before the 377 was decriminalized, the homosexuality was decriminalized, it was frowned upon. The kind of torture those people went through. It is not somebody's failing. It's how they were born. And
Right.
going by listening to Arundhati Karju, the kind of impassioned plea which they make.
Right.
as a society, yes, you have to look into every facets, every aspects of how we should, formulate laws and all, so as to ensure that there is also not, everybody's interest in taken care of. But I honestly don't see any reason why,
Right.
why this
It should-
this aspect of the decriminalization of 377
Right.
should not be factored in.
Brijesh, we will continue with the debate, but let's once again quickly dip into the Supreme Court live proceedings on same-sex marriage.
That my point is the adoption regulations go beyond the remit of the Juvenile Justice Act. If I look at Juvenile Justice Act, Your Lordship, the definition of prospective parents in 249 of the JJ Act, it uses the word person or persons. Your Lordship, if you may look at the JJ Act just for 1 second. 249, Your Lordship. My Lords, Justice Kaul and Justice Bhatt has it. The JJ Act 249, the definition, if I may read.
Yes, read please.
Prospective adoptive parents means a person or persons eligible to adopt a child as per the provisions of the section 57. Please mark these words, Your Lordship, a person or persons. Now, if I may come to section 57. Your Lordship, please note JJ Act is a secular legislation that has been said by my learned predecessors. This is not, I'm getting into personal laws. This is the only law which we had brought in adoption from the Hindu personal law into a secular legal regime. Your Lordship, if I may read section 57, clause 1. The prospective adoptive parents shall be physically fit, financially sound, mentally alert, and highly motivated to adopt a child for providing a good upbringing to him. Clause 2. This is the relevant clause, Your Lordship. In case of a couple, the consent of both the spouses for the adoption shall be required. Then 3 is a single or divorced person can also adopt, subject to the adoption regulations. 4, single male is not eligible. That's not relevant. I am on 57.2. My first submission, Your Lordship. Marital status of a prospective adoptive parent is not a relevant factor to determine the eligibility of adoptive parents, including for joint adoption, which is my Roman 3 in my note. If we look, as we had seen, the definition of prospective adoptive parents, or section 57.2, where is the word married here? If the parliament wanted to restrict joint adoption only to heterosexual married couples, because married is not just married couple. As of today, as we have seen in the last 2 weeks, it is heterosexual married couples. Which couple can marry under the Indian law at present? If the parliament wanted to restrict joint adoption under the JJ Act section 57, it would have used the word married. But it doesn't. It uses the word couple. It uses the word spouses. Yes, it may be said that as per the Indian law, couple and the spouses is a heterosexual married couple. But that is not what the legislation says. So how can the adoption regulations... Now, if I may read adoption regulations, Your Lordship, Regulation 52A, which I have challenged. Any prospective adoptive parent, it is set out in my note point B, irrespective of his marital status and whether or not he has his own biological son or daughter, can adopt a child subject to the following, namely A, the consent of both the spouses for the adoption shall be required in case of a married couple. Regulation 5.3, no child shall be given in adoption to a couple unless they have at least 2 years of stable married relationship. Where is this word marriage in the JJ Act, Your Lordship? And even Your Lordship has held, Chief Justice Justice Chandrachud, in X versus Ministry of Health, marriage is not a precondition to the rights of individuals, whether alone or in relation to one another. Your Lordship, I will not take you to the judgment. It is in the common compilation. But I am emphasizing on this phrase in para 40 of the judgment, X versus Ministry of Health. Marriage is not a precondition. So it means even this principle has to be applicable to the point of joint adoption also. Marriage is not a precondition to the rights of individuals, whether alone or in relation to one another. I'm emphasizing in or in relation to one another. Just take the example of the petitioners, Your Lordship. I am a married couple in Denmark. I come to India. My marriage is not recognized. I am dealt as two single individuals who are stranger to law. I cannot even go for joint adoption because of this regulation, which is not borne out from the text of the law. My next submission, Your Lordship, is restricting joint adoption only to heterosexual married couples amounts to discrimination on the ground of sexual orientation. Why am I saying this? Because one can say that yes, even unmarried heterosexual couples can also not adopt jointly. But they have the option to marry under the Indian law. But a same gender couple or couple involving a transgender person, they do not have the option to marry. So in effect, what the adoption regulation is doing, it is essentially restricting joint adoption only to heterosexual married couples. And that, in my humble submission, is discrimination on the ground of sexual orientation. And I will show Your Lordship from the Kara circular, which is on, if Your Lordship, compilation 2 documents, volume 2, if Your Lordship want to look at it, that is a circular dated 16th of June, 2022. And I will show how that circular even bars me in my individual capacity. That is in compilation 2 documents, PDF, volume 2, PDF 459, sorry. Your Lordship may please look at it. Compilation 2, documents, volume 2, PDF 459. This one document I want to show Your Lordship. It's a Kara circular dated 16th of June 2022. And that will show the sheer absurdity. Because it fell from the Lordship last week that a lesbian woman can adopt in her single capacity. Okay, you might not be able to adopt in a joint capacity, but you can adopt as a single person. Now I will show. Your Lordship has it, the circular? Volume 2 in documents, compilation 2, volume 2, documents, page 459, PDF page 459. Justice Bhatt and Justice Kaul has it?
Yes.
Read it here.
If I may read, just 3 lines. It's an office memorandum from Central Adoption and Resource Authority. Registration of cases of single PAPs, prospective adoptive parents, that is, having a live-in partner in a long-time relationship and not married regarding. It has been noticed from home study reports that some single PAPs registered with Kara for the adoption process are in relationship with their live-in partner. The cases of single PAPs engaged in live-in relationship have been discussed in the steering committee of Central Adoption Resource Authority held on 18th April 2022. It has been decided to go with the earlier decision of 14th, I'm not reading that, then after 10th May 2018, that the cases of single PAP in a live-in relationship with a partner will not be considered eligible to adopt a child, and their registration from concerned agencies, authorities will not be considered for approval. Then point 3, this is the main line. The decision has been taken in line with Regulation 5.3 of the Adoption Regulation 2017, which is exactly the Adoption Regulation of 2022, 5.3. The authority would like the children to be placed only with the stable family, and single applicant in a live-in relationship cannot be considered as stable family. Your Lordship, this is the Kara circular, which is barring even a single person who is in a live-in relationship from being eligible to adopt a child. All this while we have been thinking that a single person, a single queer person, a single lesbian person can adopt in this single capacity. What is the harm? You have access to adoption. But I don't. And where is this coming from? It is referring to Regulation 5.3. So just look at my state. I am married in Germany. I come to India. I am treated as a stranger in law to each other. And now I cannot even adopt in my single capacity because I am in a relationship with my partner. I am in fact a married couple as per foreign law. So as per the Indian law, as per the adoption regulations, I am not even thought fit to be eligible to apply in my single capacity. What is the effect and what is the messaging to the queer community? Your Lordship, my last point. my predecessors have talked about right to found a family. I'm saying right to motherhood. I'm a lesbian couple. I have been desiring to have a child, to adopt a child, as much as I desire to have my relationship recognized. Now, last point, Your Lordship, it is not just the right of a adoptive couple to a family. It is also the right of a child to a family. We are talking of adoption, and as per the JJ Act, who is to be adopted? If we look at section 56 of this right has been statutorily recognized. If I may read, Your Lordship, section 56(1). Adoption shall be resorted to for ensuring right to family for the orphan, abandoned, and surrendered children. These are the children we are talking, Your Lordship, orphan, abandoned, and surrendered. And they have a right to family, not just under the JJ Act, under the international law also, under Convention on Rights of Child, Article 20. The exclusion of same-gender couples and transgender persons from adoption defeats the very purpose of adoption, defeats the very essence and the object of adoption, which is what? Which is to provide a stable, a loving and affectionate family to a child. Just because I am part of a same-gender couple, just because of my sexual orientation, I will be denied this basic right, not just to myself, but even to a child who needs a loving family. And lastly, what Ms. Karju said, Your Lordship, the entire JJ Act, it is what is the guidance of this JJ Act? It is in the best interest of the child. Is it in the best interest of a child not to have a legal relationship with the second parent? Is this how we are going to advance the object and the purpose of the JJ Act? I rest my case, Your Lordship, with just last point that the petitioners, they are part of a historically oppressed and discriminated minority. Their relationship and their family deserve as much dignity and recognition as it is to be accorded to an opposite sex couple. I'm really grateful, Your Lordship. I'm really grateful.
Now,
Please, this honorable court, Your Lordship, and Your Ladyship. Yes. My lord, I'm appearing through video conferencing, and as a matter of fact, I happen to be in Germany, and my marriage was also registered in Denmark. My petition is in relation to, it seeks a declaration in relation to Section 5 of the Hindu Marriage Act, and it has already fallen from your lords that there will be no interference with personal law, but let me at least make an elevator pitch because I have only 5 minutes either which way. So I cannot expend more than 5 minutes of the Constitution bench.
But Mr. Avasthi, I think this area we have, nobody has opened. So, for us to open it in 5 minutes would be unfair because, this is an area which we have scrupulously excluded from the scope of the debate. Once we open this up in 5 minutes, it would be unfair, having regard to the canvas of the matter. And nobody else, everybody else would like to then argue the same point, I think.
My lord, I bow down. As a matter of fact, just one moment, my lord, then I leave it up to this bench. My submission only is that as per Section 4, as far as the matters with respect to which provision is made under the Hindu Marriage Act is concerned, there is no interference of any customary religious authority. And my second point is that as per Section 7 of the Act, there is no religious ceremony mandated as such. So if we were to say that if I were to be a straight, should there be a straight couple, then what we are saying is that their faith in the ceremony that they want to adopt would be enough to get their marriage to be valid under the Hindu Marriage Act, while not extending the same courtesy to a same-sex couple. So this is my submission, my lord, and to my mind, it is a violation of Article 14 of the Constitution. And because as I mentioned, as per the Act,
I think we'll leave it at that because I think we shouldn't really explore this any further. I think because this is now out of tune with what is the general line of submissions, the area which has been opened before the court. I think we'll leave it at that for the present. I think.
My lord, much obliged.
Thank you. Now the next counsel would be Mr. Shivam Singh.
Yes, Your Lordships. I'm extremely grateful for the opportunity to address Your Lordships. I'll restrict.
Right. The proceedings continue in the Supreme Court on same-sex marriage, and the discussion and the moot point being discussed is the adoption rights for the same-sex couples only if the marriage is mainstream, the marriage is accepted. Brijesh, the decriminalization of homosexuality That was something. I will come back to you, Brijesh. I think we have Harish Iyer with us, who is a civil rights activist. Harish, could you hear us now?
Yes.
All right, lovely. Thanks for taking time out. How do you view this whole episode as of now playing out in Supreme Court, Harish, when it comes to the equal rights, when it comes to the adoption rights for the same-sex couples, also the disparity in rules in India and abroad? Because two of the learned advocates mentioned that they have registered their marriages outside India, but when they come back to India, the rules change. How do you see this whole episode playing out?
I think, as Shivam, my advocate Shivam, argues my case, I'm also one of the petitioners. He just started arguing. I just have to, I just have one humble submission that we, the people from the, who happen to be Indian, and when the constitution of my country allows me to be treated as an equal citizen, this disparity is something that we need to get rid of. This disparity where different people, depending on their sexual orientation, depending on their gender identity, depending on even religion and other things, are often subject to a lot of discrimination, and whether it's the whole gamut of rights, whether it's about adoption, whether it's about property rights, whether it's about succession, whether it's about basic rights like having hospital visitation rights when your partner is, or having the right to decide what will happen with your partner if they are on a ventilator. Even those basic rights should be the right of every couple, regardless of gender, sexuality, caste, religion, creed, or any other thing. So what we are asking for is very basic rights. So you have decriminalized LGBTQI plus sexual relationships in 2018 with the historic Singh Johar judgment. So now the natural succession to something like that would be to expand the rights of marriages, because now we can legally have sex. We legally enter into relationships without anything, but our relationships will never be recognized. How is that just? How is that equality? How is that equitable as well?
Harish, wanted to ask you again that what I was meaning to ask Brijesh, that with the decriminalization of homosexuality, what possible reasons do you foresee or see? Why is it difficult to mainstream legal rights of homosexual couples on adoption, succession and marriage? Adoption is what we have seen just now being discussed in the Supreme Court.
So like, we saw this in COVID, okay, and in fact, as the learned councils had also argued about this, there were times when the natal families were not accepting of their child's gender or sexuality, and they disowned them. And during COVID, many people, and they were living in bigger cities with their loved ones who happened to be from the same sex or same gender. And during COVID, they lost their jobs and they had to go to their native families, and they were subject to a lot of abuse and discrimination over there. Also, there were times when when decisions had to be taken, where one partner was in the hospital, the other partner had to decide whether to keep the person on a ventilator, whether to start a new line of treatment, and the person wasn't able to take any decision because there's no recognition of marriage. There's no recognition of this relationship. So this is not about a couple of us going and singing Hum Aapke Hain Kaun and having mehndi in our hands. That's not something that we're seeking the right for. We can still do that. What we are seeking the right for is the right to a life of dignity, which I think should be afforded to every individual, every Indian citizen.
Harish, a pleasure to talk to you, and we wish you all the very best. And my thanks to Brijesh and Harish both for joining us on this very sensitive topic, something that is sure to decide the days to come and also shape the future that India along with the world beholds and foresees. Thank you so much for tuning in at News 9 Live. We will be back with more news and updates in just a bit.